Thank you all for joining me today and welcome to our webinar, Counsellors, Courts and... My name is Polly Richardson and I'm an Associate Solicitor with Michael Lynch Family Lawyers. Just to talk briefly about the firm, Michael Lynch Family Lawyers, we are a specialist family law firm and it's very exciting. Last year we celebrated our 20-year anniversary of practice. We have 9 solicitors, 5 of them are accredited specialists in family law. We provide advice and assistance to clients on a wide range of family law matters and assist with negotiation, mediation and, if required, court representation. You may already be subscribed to our e-newsletter, but if not, please do not hesitate to join our mailing list by just emailing us through your email address. So, in terms of the presentation today, it is really directed at family counsellors and family dispute resolution practitioners. The aim of today is to give you an overview of the family law principles and processes, and then to focus particularly on how and when you might fit into this process. The things we will talk through today are the principles of the Act, particularly as they relate to parenting matters, the resolution process that clients can go through in terms of coming to an agreement or going through the court process if required, how these agreements can be documented, the court process, and then more particularly, how do you fit into this process? When we talk about how you as counsellors and family dispute resolution practitioners fit in, we would be talking through advice obligations, notification obligations, confidentiality and admissibility of counselling sessions and family dispute resolution, subpoenas and the issues surrounding them, and voluntarily providing affidavits or reports for the court. So if we start by looking at the principles of the Family Law Act so far as they relate to parenting matters, the most important thing to know, and probably many of you already know, is that the child's best interests are the paramount consideration for the court. It's also important for usually both parents to have a high level of meaningful involvement in their children's lives, and that's certainly the aim of legislation. Parents should try to reach an agreement about parenting arrangements rather than relying on the court processes to determine that for them. So the 2 main parenting issues that parents need to decide, or the court needs to decide for them following separation, are parental responsibility and living arrangements for children. So parental responsibility is actually defined in the Act, and it's defined as all the rights, powers and duties that parents ordinarily have in relation to their children. That responsibility relates to both decisions about day-to-day issues and major long-term issues. Day-to-day issues are things like what time the children go to bed, who can care for them other than their parents, what they eat for lunch, those sort of day-to-day decisions. Major long-term issues are defined in the Act as those that relate to children's health, education, changes to their name, and changes to their living environment that may make it significantly more difficult for a parent to spend time with them. The Act provides that whenever a court makes an order, whether they're making a determination of their own volition or approving consent orders that are agreed to by the parents, which we'll talk through shortly, the court must apply the presumption that it is in the best interest of the child for their parents to have equal shared parental responsibility for them. An order of equal shared parental responsibility means that parents must consult with each other and make a genuine effort to come to a joint decision in relation to the long-term issues, being education, health, changes to name and changes of living arrangements. That presumption does not apply if there is family violence, and it can be rebutted if there are other reasons why it's not in the child's best interest for parents to have equal shared parental responsibility. The alternative, I should say, to equal shared parental responsibility, which is the required position in most cases, is sole parental responsibility. So one parent having the sole power to make all those decisions, those major long-term decisions, and sometimes one parent will have sole parental responsibility for a particular area, such as the child's education, for example. Day-to-day issues continue to be the sole domain of the parent who has the care of the child at that particular time, so you don't need to consult about or have a say in what the other parent's feeding the kids for dinner or other daily decisions as they come up. Excuse me. The flow-on effect of how parental responsibility is exercised for a child's living arrangements is that if parents have equal shared parental responsibility, then the first type of living arrangements that the court must consider is the child living in an equal time arrangement with both parents. However, only if it is in the best interest of the particular child and it is reasonably practicable. If it is not in the child's best interest, nor is it reasonably practicable, then the next arrangement the court must consider is substantial and significant time. And in my experience, this is the type of arrangement that's occurring in the majority of separated families. So what that means is that the children live primarily with one parent and spend time with the other parent that is substantial and significant. And in reality, that means not just time on weekends, but also time on weekdays, school holidays and special occasions. And the aim of that is that it allows the children to be involved in the day-to-day life of the other parent and vice versa, the parent being involved in the day-to-day experiences and requirements of the child, like having to have an argument about when to do homework, brushing teeth, things like that. Again, substantial and significant time would only apply if it's in the best interest of the particular child and if it's reasonably practicable. And when I say reasonably practicable, we're essentially talking about, do the parents live close enough to one another that they can facilitate getting the children to the same school? And do they have a level of cooperation between them, which means they can reasonably cooperate if, for example, a child leaves their runners at one parent's home and they need them for school when in the other parent's care, those sort of practical issues. So let's turn to determining best interests of a child. Excuse me. The child's best interests are and should always be the most important consideration for the court and for parents when trying to reach agreement regarding care arrangements. The Act specifically, at section CC, sets out the considerations when determining best interests, and these are primary considerations and additional considerations. So the primary considerations are the benefits to a child of having a meaningful relationship with both parents and the need to protect the child from physical or psychological harm and from being exposed to abuse, neglect or family violence. The Act specifically says that if there's a conflict between those two primary considerations, the need to protect the child from harm takes priority. Section 60cc also sets out 13 additional considerations that the court must take into account when looking at the child's best interest and includes things like the child's wishes and views, capacity of each of the parents to provide for the child's care, the extent to which they have been involved in the child's life and taken an interest in the child's life, as well as their attitudes to responsibilities of parenthood, etc. So these considerations essentially say that if there is anything specific to the child's circumstances which should be taken into account when determining best interest, they should be looked at by the court. So now, in terms of the resolution processes that parents can use to get to a point where they have orders or an agreement about parental responsibility and living arrangements, the first means of reaching agreement can be achieved by direct negotiations between the parents, and obviously that's the ideal outcome. If those direct negotiations don't work, then sometimes people will see a solicitor, get some advice, and the solicitors hopefully will assist them to negotiate an agreement. There's also family dispute resolution, which, as many of you are aware, is the mediation process to assist and encourage parents to come to an agreement in relation to the arrangements for their children. FDR is in fact mandated by the Act in that parents must attend or at least attempt to arrange family dispute resolution prior to making an application to the court, unless there are circumstances of urgency or family violence. And if none of those processes are successful, then as a last resort, one parent may need to consider a court application. If the parents are able to come to an agreement after one of those processes, there are a few options in terms of documenting that agreement. The first is obviously to keep arrangements completely informal, and many families choose to do that if they feel comfortable that those arrangements will be followed and that there's a level of trust between the parents. If the parents want to make the arrangements more formal and reduce the arrangement to writing, then the two options are parenting plan and consent orders. So let's first look at parenting plans. So a parenting plan is a written agreement that sets out the arrangements for children, and it can be quite detailed in its terms. It can include things like what's to happen during school holidays, on birthdays, other special occasions, and can cover things including extracurricular activities that children might like to be involved in. It can be quite specific depending on the needs of the parents. However, in order for it to be valid, it must be signed and dated by both parties and made free from duress. The benefit of a parenting plan is that it's quite flexible, but the downside is that it's not strictly a legally binding and enforceable document. And what that means is that if a parent breaches a term of the parenting plan, there is no means to enforce the terms on the other parent. However, if the matter later goes to the court must have regard to the terms of the parenting plan, and usually an explanation as to why someone has departed from those terms would be required. The alternative means of formalising an agreement between the parents, which is legally binding, are consent orders. And essentially that means the agreement between the parents is reduced to writing, signed by both of them, and submitted to the family court with an application form. If the court is happy with the orders, that is, the terms are in the best interest of the children or child, the court will approve those orders, and then those orders become binding and enforceable, just as if the court had made them of their own volition. So once made, parents can be punished essentially for failing to comply with the terms of the order, and there are a variety of different contravention remedies available to the court depending on the seriousness of the contravention. It's important to know that if parents do enter into a parenting plan, the court must have regard to it, and if the parents enter into a parenting plan after orders have been made, either by consent or as decided by the court, the terms of the subsequently entered parenting plan can override the order, even though the parenting plan is not legally binding and enforceable of itself. Just something to be aware of. In terms of court proceedings, the process begins with an application where one party files an application in the court, seeking the court make particular orders, and that application is supported by an affidavit signed by that party, and perhaps from other people setting out their evidence to support why they would be seeking the orders they seek in their application. The other parent must be served with the application once that application is filed with the court, and the other parent should respond by filing a response setting out the orders they seek and an affidavit with their supporting evidence. The matter then comes before the court for a first court event. We refer to them as first return dates or mention dates. And at the first hearing, the court wants to assess what the case is about, what further evidence might be required in order to make a decision, and also perhaps to make some interim orders about what should happen in relation to the children, pending that further information being made available. I just wanted to touch quickly on family reports. Many of you may be aware of such reports, and in almost all cases the court will order the preparation of a family report. A family report is an assessment by a social worker or psychologist who has experience in dealing with family law parenting matters. The family report writer will undertake an assessment of the family for the purposes of providing a report to the court. And that involves interviewing each of the parents and any significant adults involved in the child's life, as well as observing the child interacting with the parents. And this observation for young children might be observed in a play session, and with older children it might be observing interactions when the family are all together in the report writer's office. The report writer also may interview the children depending on their age and how appropriate it is to question the children about their living arrangements, and they'll also read all the documents that have been produced to the court, so that includes both parties' affidavit material and any documents that have been subpoenaed, which might include things like reports from counsellors or notes from a counsellor. The independent children's lawyers also may be appointed as a separate representative for the children, and their role is to advocate for the child's best interest rather than what the children or child wants. The ICL do not take direct instructions usually from children, and they're funded by legal aid, so they're separate to the parents. ICLs tend to be appointed in cases that are particularly difficult, such as if there's been substance abuse issues, mental health issues, or there's an international relocation application before it. And also in circumstances where a parent or both parents are not legally represented in the court proceedings. Now, the other stages of the process in terms of court proceeding are the interim hearing and the final trial. It's probably easiest to talk about the trial first, in that that's the end date that all court processes are working towards. And this is where all witnesses in the case will give evidence and be cross-examined on that evidence. The parties or their lawyers will make submissions about the case, and the judge will then make the final decision. And that is the only opportunity that the court really has to be testing the evidence of each of the parents and to make a final decision. So by contrast, the interim hearing, which is a hearing somewhere along the way, and usually there may be several before you get to a trial, at those hearings there's no cross-examination or testing of witnesses. So independent evidence at interim hearings is valuable because often the parents each say something completely different to the other. Their stories are completely different and the court has no way of knowing which of the parents is more credible about the disputed facts. And that independent evidence may be the family report, which we were just talking through, a report from a counsellor or notes that have been produced by a counsellor, which can be quite important at these interim hearing stage. So that's the process that the court proceedings go through, and it's very much a process. Statistically, at the moment, less than about 10% of cases that actually start in the court process make it through to the final hearing. So despite a matter starting in the court, most cases do settle along the way, particularly after a family report's been produced, because it's such an important piece of evidence and quite persuasive on both the parties. Whilst the court is not bound by the recommendations of the report writer in the family report, it's normally pretty persuasive and most people will accept them and settle the matter rather than proceed to a trial because of the cost and delay involved there. So in terms of talking about how all of you fit in with the family law process, the first topic I want to talk about is what are your advice obligations? So do you have to tell a client what the Family Law Act says? The answer is basically no, unless you are an advisor. Now, an advisor under the Family Law Act are lawyers, family counsellors as defined, and we'll talk about that in a minute, family dispute resolution practitioners, again as defined in the Act, or a family consultant. So if you do fall into one of those categories as an advisor, you do have an obligation to provide advice regarding the child's best interests, that is to tell the parents that you're dealing with that the child's best interests are the most important consideration, that the child's best interests can best be met by having a meaningful relationship with both parents while being protected from harm, and that being protected from harm is the most important. In terms of obligations regarding parenting plans, those obligations are quite detailed and provide the obligation to give advice to parents about the options of having a parenting plan, the types of things that a parenting plan can include, where that person can go for more advice about complying with or entering into a parenting plan, and also the issues of parental responsibility and the obligation to consider if the parents have equal shared parental responsibility and equal time arrangement. So those obligations are quite detailed if you are an advisor. The next issue then, if you are an advisor, is what are your notification obligations? Essentially, what the Family Law Act says is that if you have an obligation to notify appropriate authorities if it is necessary to comply with the law of the Commonwealth, state or territory, and also an obligation to notify if a child has been abused or is at risk of abuse. The Family Law Act was amended in 2012 to expand the definition of abuse. So abuse includes assault, including sexual assault of a child, involving a child in sexual activity, either directly or indirectly as a sexual object, serious psychological harm, including harm from being subjected to or exposed to family violence, or serious neglect. In particular, that expanded definition to include exposure to family violence, with with family violence having quite a broad definition now. So it has significantly expanded what constitutes abuse and what needs to be reported. One of the main topics we're talking about in this presentation is the issue of confidentiality, which I appreciate is a key issue for many of you. The starting point really is non-confidentiality, starting from a point of assuming that everything can be disclosed, everything can be subpoenaed, everything is admissible. So, for example, statements to GP, psychologists, therapists, even if the participants treat them as confidential, can be non-confidential. Why is that? So the courts can be provided with the, in inverted commas, truth, or at least objective evidence that is not each parent's evidence. So non-confidentiality is the starting point for you in terms of any sessions that you have with patients, either as a counsellor or a family dispute resolution practitioner. There are, of course, exceptions in the Act about whether material and communications are confidential, so we will talk about those. Those relate specifically to family counselling as defined and family dispute resolution as defined in the Act. So what is family counselling? It is a process in which a family counsellor helps parties or children with issues relating to marriage, separation or divorce. And you can see section 10 capital B for that. Importantly, a family counsellor must be authorised in accordance with section C of the Act. There are 5 categories in section 10C, including, for example, complying with accreditation rules, etc. But in practice, at the moment, there is actually only one of these categories that's capable of being fulfilled, and that is if a person is authorised to act on behalf of an organisation which has been designated by the Minister. And there is a list of those organisations on the Attorney General's website. Those organisations designated by the Minister to provide family counselling include the well-known ones such as Relationships Australia, Centre Care, Uniting Care and Lifeline. So unless you are working for and are authorised by one of those organisations designated, you don't come within the definition of family counsellor for the purposes of the Act. You may be providing family counselling in the ordinary meaning, but not family counselling as defined in the Act and not as a family counsellor as defined in the Act. And for those interested, that's from the case of Cooper and Cooper, spelt the normal way, in 2012. In terms of family dispute resolution, or FDR, it's a process in which an FDR practitioner assists parties to resolve issues relating to separation and divorce. Again, a family dispute resolution practitioner must be accredited under section 10 capital G of the Act. And generally that means by complying with, again, with accreditation rules, completing a course, doing some supervised sessions, and then being accredited. As I mentioned earlier, family dispute resolution is now compulsory before parents can proceed to court, unless one of the exemptions such as family violence or urgency apply. So let's talk about confidentiality in those processes. Communications made during family counselling with a family counsellor as designated under section 10C and or during family dispute resolution are confidential and inadmissible unless an exemption applies, and that's from 10D, 10E, 10I and 10J of the Act for those playing along. Essentially what 10D and 10I say is that family counsellors, as defined, and FDR practitioners must not disclose the communication made in family counselling or FDR, but they must disclose to comply with the law, that is reporting abuse, etc. And they also may disclose if patients' clients consent, if the disclosure seems necessary to protect a child from harm, or report an offence, or to assist the independent children's lawyer or ICL. It's really important to note that there is a distinction between communications that may be disclosed and the admissibility of those communications. And when we're talking about admissibility, we're really saying, are those communications admissible as evidence in the court? Communications which are made during family counselling and or family dispute resolution are not admissible unless there has been abuse or there is a risk of abuse. And you can see section 10E and 10J of the Act. for that. So what that means is that communications that may be disclosed, for example, if all parties consent, or to help the ICL, are still not admissible in the court proceedings. Essentially, Section 10E and 10J say that evidence of things said with a family counsellor or FDR practitioner conducting family counselling or FDR are confidential and not admissible. However, the exemption to that is an adult's admission of child abuse or child's discussion of abuse, unless the court believes there is sufficient other evidence of the admission or disclosure from another source. So given that we've now discussed the dryness of the law, I just wanted to talk through a few cases that demonstrate the effect of these sections in terms of confidentiality and admissibility issues. The most important one probably is the Uniting Care Unifam case. This was a case where one of the parties had subpoenaed the counselling notes from a family counselling process with Uniting Care. The court had in fact made an order that Uniting Care should produce those documents, and it went to an appeal. The appeal court said that the wording of section 10 D3 means that the discretion remains with the family counsellor whether to disclose, even if the parents consent or the court directs. Section 10D says that there are some categories where a counsellor may disclose, including when the court directs or the parent consents. This case determined that despite that, it's still up to the family counsellor, even if the parents have consented or the court directs. The discretion remains with the family counsellor whether or not to disclose the communications. Again, it's important to note that even if the communication can be disclosed, it is still not admissible in the court proceedings unless it relates to abuse or risk of abuse of a child. Another case that's important on this issue was during the 2013 Baden-Clay case. That decision, as it relates to family counselling, confidentiality and admissibility, essentially involved a family counsellor from whom the police sought to obtain evidence to use in the murder trial. The Supreme Court held that Section 10D and 10E of the Family Law Act, which say that communications during family counselling and FDR are confidential and can't be admitted to court, only applies to courts which are exercising family law jurisdiction by virtue of the Family Law Act. So, the court decided that the application of Sections 10D and 10E is limited to courts exercising power provided to them by the Family Law Act. The court in the Baden-Clay case was the court acting in its criminal jurisdiction and not exercising any jurisdiction under the Family Law Act. Therefore, the inadmissibility provided by those sections 10D and 10E did not apply. That decision has possibly quite far-reaching implications for other non-family law matters, including domestic violence matters, which operate in a state-based jurisdiction rather than a federal jurisdiction. Interestingly, in relation to the domestic violence aspect, the Family Law Act says that if there is a domestic violence order between the parties that needs to be disclosed to the court, as do the circumstances in which that order was made, including evidence that was relied upon to make that domestic violence order. So I haven't heard of a case yet in relation to this, but I expect that it will come, where in the domestic violence case, someone subpoenas the notes from the family counsellor. They're not confidential because it's not in a family law jurisdiction. A protection order is made, and that needs to be disclosed to the court, along with the evidence upon which that order was made, which could result in the evidence from the family counsellor being disclosed in the family law proceedings via a domestic violence application. Prior to the Baden-Clay decision on this issue in 2013, the issue was already flagged as one that needed revisiting, and the issue was included in the Australian Law Reform Commission's report, Family Violence National Legal Response in 2010. So really, it's a matter of stay tuned. Interestingly, in the Baden-Clay case, just as a note of interest to you all, the counsellor raised as a basis for the inadmissibility of evidence by them an argument that the public needed to have confidence in the confidentiality of the counselling process because knowing the counselling was confidential encouraged people to engage in the counselling process. The court, however, said that in this particular case, that confidence was outweighed by the public interest of having all possible evidence available to the court in determining this most serious of offences, being murder. There have been a few cases which have dealt specifically with parenting plans, and I just wanted to talk through some here. It's important to note that a valid parenting plan that is signed and dated, made at the conclusion of a family dispute resolution process, is admissible and not confidential, even though it's made during the FDR process. Obviously, it would defeat the purpose of engaging in the FDR process if the agreement you reach at the end could not later be relied upon. However, an agreement reached at family dispute resolution will be inadmissible unless it is properly documented as a parenting plan. So it needs to be signed, dated and made free from duress. Unless it meets those criteria to be considered as a parenting plan, that it is just a document prepared during FDR and it's not admissible and it's confidential. Interestingly, a recent case dealt with a situation where there was what appeared to be a validly signed and validly entered parenting plan made during the FDR process, but the father alleged that actually it was made under duress. The court held that any evidence from the FDR process which would tell us whether or not there was duress was actually inadmissible. So the court was caught in an unusual situation where they couldn't take any evidence about the process involved in reaching the parenting plan. It appeared on the face of it to be a valid parenting plan, but the court had to find that because there could be no evidence from the FDR process regarding the alleged duress, they didn't know whether or not the parenting plan was made free from duress. So it's not going to be a parenting plan. And that's from the case of Roux, R-O-U-X, and Herman in 2010. Another interesting point that's come up in a few cases is, what is family dispute resolution? When does it begin and end? And therefore, what parts of it are confidential? There are two cases which are completely conflicting and don't appear to refer to the other. This is certainly an area which needs further determination by the courts. The first one is Restall and Ball in 2010, and it basically said that FDR is a two-stage process because the family dispute regulations require a practitioner to undertake an assessment of the parties for suitability to undertake an FDR process. What the court said was that the assessment process is separate to the actual FDR process, so that assessment process is not confidential. The parties had all agreed to attend FDR, the court had directed them to attend FDR, and then it was Centrecare, I think in that case, conducted approximately 7 hours of sessions with the parties and ultimately come to the conclusion that it was not suitable for FDR because it was unlikely to resolve the matter. The court obviously wanted to know why. If the court had thought FDR was appropriate and the parties were agreeing to FDR, Centrecare had decided it wasn't appropriate. So in that case, it was ordered that the assessment process notes were not confidential and could be admitted into the court. The other case was French and Winter, and it's a Brisbane case. And in that case, the mother attended upon an FDR practitioner, although she attended for the purposes of counselling. The practitioner, however, said, "I don't do counselling anymore, I only do FDR." The mother attended alone 4 days before the final trial, and she said it was to help her focus on the needs of the children. So in no way was she seeking the family dispute resolution process. However, the court decided in that case was that the FDR practitioner thought that's what they were doing, and even if it was a one-off session, that could be part of a process that begins with one session for one party for engagement with the other party, and that could all be part of the FDR process, and all the FDR process is confidential. So those cases are completely conflicting, and just like most of the aspects of these confidentiality provisions, they haven't been properly tested in the courts, which leaves, unfortunately, a lot of uncertainty about when and how communications will be confidential and what does and doesn't form part of family counselling and FDR. Not much comfort to all of you, I imagine. Again, talking about the family counselling process and what does and doesn't form part of that. As I said before, it's really important that the confidentiality provisions only apply to people who are accredited counsellors as per Section 10C, i.e. working for an organisation that's been designated by the Minister. Otherwise, the family counselling confidentiality provisions do not apply. And even where they are working for organisations that are designated, the counselling still needs to meet the criteria for family counselling. In one case, the court basically said that the meetings between the children and a family counsellor do not come within the definition of family counselling in the Act, and therefore the confidentiality and inadmissibility provisions do not apply to this type of counselling, notwithstanding the claim made by the Director of Counselling and Family Services of the particular agency that it was designated by the Minister pursuant to Section 10C. The counsellor was not providing counselling related to the marriage breakdown or interpersonal relationships of the parents and the effects of the breakdown of the relationship. The parties had been separated for over 5 years, and the issues between them had to do with the quality of care provided by each of them to the child. And that's from the case of Kidd and London, K-I-D-D, Kidd and London, and that's a 2011 case. Another case involved a process where the child and the parents were undergoing attachment therapy, and the court said, unless we know what attachment therapy is as distinct and discrete from family counselling, or it is clearly family counselling, then it's not family counselling, and that attachment therapy process was therefore found to be not confidential and could be admitted into the court proceedings. And that's from Smirov and Turova in 2009. I just wanted to quickly touch on the issue of whether you can be required to give evidence to the court. As you no doubt have gleaned from this webinar today, the answer is yes, and the way that it is normally done is through a subpoena. Subpoenas can be issued from any of the courts exercising family law jurisdiction or other courts such as in domestic violence matters, that being the Magistrates Court. And the subpoena can either be for you to produce documents or to give oral evidence to the court. Another option is that you might be asked by a parent or by their lawyer to provide a report about the client attendances with you. If that is to be admitted into the court, then it normally needs to be attached to an affidavits form by you to be submitted to the court and is able to be relied upon. Subpoenas compel you to give evidence. The court has directed you to give that evidence, so you must either produce the documents to the court or attend to give evidence as the subpoena directs. There are penalties if you don't apply. There are some limited grounds that you can object to the subpoena. For example, if the information sought is irrelevant or too broad. You are entitled to be paid conduct money for producing those documents to the court, and you can also ask for costs of actually having to attend court if that's what the subpoena seeks. My suggestion would be that it's prudent to inform your patient or client that you've been subpoenaed by the other party, and also to seek some legal advice prior to producing those documents to the court. Even though it's likely that if the subpoena has been properly prepared and properly issued to you, you'll have to produce those documents. It's always prudent to get some advice about that subpoena before just posting everything off to the court. And my understanding is too that if you contact your professional indemnity insurers, often they'll be able to provide you with or put you in touch with someone who can provide you with legal advice about the subpoena before producing the documents. It's important to note that your patient will be aware that their material has been subpoenaed, and if it's the other party to a proceeding seeking it, perhaps it's also prudent to make them aware. It also, they'll understand they have an opportunity to object to the documents that are sought by way of the subpoena. If you're voluntarily producing something like a report for a patient, it may well end up being used in the court process. As I mentioned, a report normally must be attached to an affidavit, which a solicitor would prepare. And the affidavit would say something like, I'm a psychologist registered to practice in Australia. I was asked to prepare a report. A copy of my report is attached and I believe it's true and accurate. If you produce an affidavit voluntarily like that to the court, you should be aware that you could be called to give oral evidence at an interim hearing, or more likely, obviously, the final hearing, and be cross-examined about the content of your report. So really, to summarise, it's important to know that the default position for you is non-confidentiality. the interpretation of the confidentiality and admissibility provisions in the Family Law Act is still quite unclear, and there are many exemptions that apply. So you should really assume that your notes can be subpoenaed and you can be compelled to give oral evidence. Obviously, there are exemptions that apply, but there's always that possibility. So you should bear that in mind when you're dealing with patients and keeping your notes of those sessions. So thank you all for your attendance today. An audio recording of this webinar will be made available, and if you'd like a copy, please just email us. It will also be made available on our website under our Media tab. If you do have any questions on the topics that I've discussed today, I'd be happy to receive those by email following today's webinar. So thank you again for your attendance.